welcome to 5-Minute Family Law. Today, we're talking about getting married in British Columbia. Now that you've made the decision to get married, there are two things you need to figure out. First, you need to understand the law and the legislation on marriage, and once you've got that under control, then you need to figure out how it is that you actually go about getting married. Before we talk about that, I just want to say a few words about common law relationships. You often hear people describe couples who have been living together for a long time as common law spouses who are in a common law marriage. Now, while it's absolutely true that the Provincial Family Law Act recognizes people that have lived together in long-term unmarried relationships as spouses, there's no such thing in British Columbia as the common law marriage. That actually used to be a form of marriage that was valid, where you didn't need to get permission from the state or permission from the church to get married, but the reality is that that hasn't been available since the early 1700s. Now, let's talk about the legislation on marriage and getting married. The Federal Civil Marriage Act is the law that allows same-sex couples to get married across Canada in exactly the same way as opposite-sex couples. The Marriage Prohibited Degrees Act is the legislation that sets out the degrees of relatedness within which you cannot be in order to get married. The act, in a nutshell, says that you can't marry your parents or your grandparents or your siblings, whether you are related to them by blood or by adoption. The Provincial Marriage Act is the law that sets out the nuts and bolts about how it is that you go about getting married in British Columbia. Now, not all marriages are created equal. The kind that most people want is the valid marriage, but some marriages are invalid, other marriages are void, and still other marriages are voidable. So, the requirements of a valid marriage. Well, you can't be within those prohibited degrees of relatedness. Unsurprisingly, you can't be married to someone else when you're getting married. Third, you really have to have the mental capacity in order to understand the nature of the ceremony and what it is that you're getting into, and you can't be too young. Finally, the marriage also has to be properly celebrated under the laws of the place in which you are getting married. A void marriage is a marriage where the technical requirements of a proper marriage are just simply missing. They are absent to such a degree that the marriage isn't considered to have ever even happened. A marriage that is void is a marriage between persons who are within those prohibited degrees of relatedness. A marriage might be void if one of the parties to the marriage was already married at the time of the ceremony. It can be void if one of the parties did not understand what was going on, or if one of the parties was below the common law age of consent, which, in case you were curious, is 7. Marriages that are potentially voidable are marriages involving a man who is impotent or a woman who is sterile, marriages in which the marriage can't be consummated, and consummation isn't just simply a matter of not having had sex. It has to do with an inability to have sex, or, and I kid you not, this is from the case law, where someone has an invincible repugnance to the idea of having sex. A marriage can be voidable if it was a sham, in other words, if it was entered into for a collateral purpose, such as immigration. A marriage can be void if one of the parties agreed to marry as a result of fraud or misrepresentation. And I remember a case from law school in which a woman married the identical twin of the man she was dating. That's a pretty good example of misrepresentation. A marriage can be void if one or both of the spouses did not enter the marriage voluntarily, or if one or both of the spouses were below the common law age of puberty, which, again, in case you were curious, is 12 for girls and 14 for boys. An invalid marriage is a marriage in which one of the technicalities wasn't met, such as not having the right number of witnesses, not having witnesses at all, or not having witnesses who were 19 years old or older, a marriage who was celebrated by somebody who didn't have the legal ability to conduct a marriage in which there was a technical mistake in the marriage ceremony or in the marriage license, or a marriage involving someone who was below the minimum age prescribed by the legislation. The British Columbia Marriage Act says that you cannot get married unless you are 19 years old or older, unless you have the permission of a judge who can allow you to marry as young as age 16. It's important to understand, however, that even though a marriage is potentially invalid, there are a number of important legal presumptions in the law and in the Provincial Marriage Act that are designed to preserve these marriages and treat them as if they were proper, valid marriages. All right, so now that you've absorbed all of that, it's time to get married. First thing you need is a marriage license, and you can get a marriage license from any marriage license issuer within the province. And the Vital Statistics Agency, which is a department of the Government of British Columbia, has a really helpful search tool on its website that will help you find the marriage license issuer nearest you. Now, when you're on your way to the marriage license issuer to apply for the license, you'll need some information about yourself and your fiancé. You'll need to know your full legal names, current addresses, dates of birth, and places of birth. As well, if either of you had been divorced in the 31 days preceding the application, you also need to bring proof of divorce. That will either be a divorce order or a divorce certificate, one of the two. It will cost you about $100 to apply for the marriage license, and the license will be good for 3 months from the date on which it was issued. And what that means is that if you don't get married within those 3 months, you'll have to go back and apply for a new marriage license. So, now that you are armed with your marriage license, you need to get married, and you have two choices. You have a civil marriage or a religious marriage. Civil marriages are performed by marriage commissioners who are licensed by the Vital Statistics Agency. Religious marriages are performed by religious officiants who are registered with the Vital Statistics Agency. And so it's important that when you're getting married in a religious ceremony that you ask the officiant to make sure that they are in fact registered with the Vital Statistics Agency, just to make sure that your marriage is on the up and up. Now, a marriage commissioner will charge you about $75 for the ceremony and also expect to be compensated for certain expenses such as travel expenses. You will be required to say certain vows that are prescribed by the Provincial Marriage Act. You can work with your religious official or the marriage commissioner to create your own vows, and that's just fine, as long as the vows include the minimum vows that are prescribed by the Provincial Marriage Act. You will also need to get married in the presence of at least 2 other people, each of whom have to be at least 19 years old. These people are your witnesses, and at the end of the marriage ceremony, what will happen is you will sign the marriage certificate, the marriage commissioner will sign the marriage certificate, and your 2 witnesses will sign the marriage certificate just to say they were there and they saw you actually getting married. And that's it. Congratulations, you're married.